It looks like Mr. Azultine, I may be pronouncing that wrong, is had a fairly recent warrant. I would be we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
Welcome back to Judgment Unfolded, where real courtroom moments meet deep analysis. Today's video features not one, but two back-to-back hearings where defendants attempt to outsmart the system using sovereign citizen logic. From claims of being living men to denying jurisdiction altogether, both cases spiral into legal chaos before the judges step in with calm, precision, and just a touch of disbelief. In our first case, Mr. Azultine refuses to identify himself as a defendant, declaring he's a living man under duress.
Before I feel comfortable with this court moving forward, has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yep. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
Here we go. The sovereign script begins. Notice how he immediately distances himself from the name on the case, calling it a corporate entity. This tactic is meant to reject the court's authority, but it has zero legal standing. These so-called affidavits of truth are self-created documents with no basis in law. Judges have seen it all before, and the moment someone says, "I am the living man," you can almost hear the gavel tightening. The court knows it's about to be a long morning.
Number 24, RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the...
Mr. Mathis, today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, air near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mister?
This is where the judge's patience shows real skill. Instead of engaging with the nonsense, she keeps the focus on one issue, confirming the defendant's identity. She refuses to be drawn into pseudo-legal traps or philosophical arguments. When she says, "If you're not the defendant, you're a spectator," it's a calm but powerful reminder that the courtroom deals in facts, not beliefs. It's professionalism meeting performance, and only one side plays by the rules.
Mathis, you have three options, and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine, and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have.
And there it is, the mute button, the ultimate equalizer in Zoom court. Judges rarely use it unless absolutely necessary, but when they do, it means a courtroom order has officially collapsed. Mr. Zalton's refusal, confirm his name, leaves the judge with no choice. She strikes the hearing and keeps the warrant active. It's a clear message. You can't outword your way out of jurisdiction. The law runs on clarity, not creativity.
Be the truth, so help you God.
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
And that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
Without missing a beat, the court moves on to the next case. And guess what? We're about to see the same playbook in action. New name, same arguments. This time, it's Anthony Winston Mathis, or as he calls himself, the living man here in special appearance. If you thought the last hearing was bizarre, this one takes it up a notch.
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or
Where's
are
the
you
city?
asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
Where is the city?
The judge gives a masterclass in patience here. She offers 3 simple options: admit responsibility, admit with explanation, or deny responsibility. Instead of choosing, Mr. Mathis says he only pleads to the Most High. This is classic sovereign rhetoric, spiritualizing legal terms to reject authority. But watch how the judge stays calm, almost unshakable. She repeats the process, sets the structure, and keeps the courtroom anchored in law. This composure is why experienced judges rarely lose control. They've heard every variation of, "I don't consent."
Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under
the officer,
the vehicle code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case.
Why are you trying to
the motor
charge
vehicle
me?
code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any
This part always comes next. The "where's the injured party" argument. It's one of the most common sovereign misunderstandings. In civil traffic cases, there's no injured party because it's not about harm. It's about violating administrative law. The city of Royal Oak isn't a person. It's a governing entity enforcing road safety. The judge explains this clearly, yet the defendant keeps circling back, asking for someone who doesn't exist. This moment perfectly captures a gap between personal belief systems and actual legal frameworks. It's frustrating, yet fascinating to watch unfold in real time.
Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of 2 cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling You may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
And there it is, the final ruling. The judge finds Mr. Mathis responsible and sets a $175 fine. It's straightforward, procedural, and fair. But what's most interesting isn't the fine. It's how both defendants refuse to engage with the process designed to help them. One could have cleared a warrant in minutes. The other could have simply explained a traffic ticket. Instead, both doubled down on flawed ideologies that only hurt their own cases. These hearings remind us that knowledge of the law isn't power. Understanding it is. Judges don't win by emotion. They win by staying grounded in procedure. And for viewers like you, that's the real takeaway.